We are now live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Morning. Welcome to the Appeals Court. I am William Meade. Sitting with me today are Justices Blake and Neyman will be the panel for the case today. As you can see, sometimes there are snafus with Zoom, and we do our best to remedy them. If we lose any connections, we'll do our best to reestablish that connection, and no one will be docked any time for any technical issues. If any of the judges have questions while you're arguing, please pay attention. Sometimes it's hard to interrupt during a Zoom argument. If you see any of us gazing off to the side, it's because our notes are probably on a separate screen and we're not watching ESPN or anything. So with that, we'll call the first case. It's 20P1238, 39 and 40. They were combined for arguments. And with that, Mr. Ravitz.
Good morning, Randall Ravitz for the Commonwealth. This court should vacate the motion judge's decision dismissing 9 counts of labor trafficking against the defendant, Martin's Maintenance. In this court's de novo review, the question that should be asked is whether there is any way of viewing the evidence that would have permitted the grand jury to find probable cause to believe that the company committed labor trafficking based on the conduct of Fernando Roland. And there is, based on 2 theories of liability. In concluding otherwise, the motion judge applied certain civil law tests that were inappropriate, and he does not recognize that even if those tests are applied, probable cause should be found. The
Mr.
first theory.
Could I ask you, we have to find there's probable cause under both theories, or is one sufficient?
One theory would be sufficient.
And as to the 2 theories, one being vicarious liability and one being the collective knowledge doctrine, which do you say is the stronger case for the government?
Well, we would say that they're both strong, but that the court would not need to reach the collective knowledge issues if it finds that the simple test for corporate criminal liability that would suffice to establish liability under the first theory is met. And I say that that's a simple test because it has been refined over the course of 50 years, and it's been reduced to 3 elements. And the first asks whether an individual committed a criminal offense. And it appears.
Let me interrupt you, Attorney Ravitz. Let's go to the 3rd prong, which I think is mainly at issue here. And there's this language from LAL Corporation, quoting from the instructions in Beneficial Finance Corporation. And let me read it to you in part, okay?
Yes.
It talks about the agent or principal having, quote, had enough power, duty, responsibility, and authority to act for and in behalf of the corporation to handle the particular business or operation or project of the corporation in which he was engaged at the time that he committed the criminal act, with power of decision as to what he would or would not do while acting for the corporation. My question for you is here, are we talking about the power of decision to perform janitorial services, or are we talking about the power of decision to hire and supervise the victim?
We would say that it's the power and authority with respect to cleaning services, but that even if the court were to focus on the power to supervise others, there would be enough to establish probable cause. But I'll go back to.
Let me stop you right there.
Yes.
How do we determine the first part before we get to the either or response that you're giving? Can you guide us?
Yes. Well, any conduct, as we discussed in our reply brief, or virtually any conduct, can be characterized in different ways. So, for example, the driver in the Angelo Tedesca case who backed up without using a backup alarm and struck and killed a police officer. His conduct could be characterized as hauling asphalt, in which case it clearly would have been within the scope of his authority, or his conduct could be characterized as striking and killing a police officer, in which case it wouldn't. And so it shouldn't be the case that a defendant can pick which way to characterize the conduct and then proceed from there. But neither does this court need to pick one way of characterizing the conduct, at least not in a circumstance like this, because the question should be, is there any way of characterizing the conduct that would have been supported by the evidence and that would justify a finding of probable cause? And here there was. Again,
Is there
that
danger in that. Finish your answer, and then I have a follow-up. I'm sorry.
Right. Well, the third element builds on the second. So the second element asks, at the time of the offense, was the individual involved in a corporate project? And to use the language of Angelo Tedesca, was the individual engaged in some particular corporate business or project? So as long as he was, as long as we can identify some project in which he was involved, and it's supported by the evidence, then we take that project and we move on to the third prong and ask whether he had authority to perform that particular project. So here, the easiest way to answer these questions is to say, yes, he was authorized. He was involved in the corporate project of ensuring the cleaning of clients' facilities.
Isn't
And then
the
we move on
danger,
to
and I'm going to interrupt you, sorry, isn't the danger in that interpretation that it's overbroad? That under that interpretation, a corporation can be held liable for almost anyone doing anything within, as long as they are performing the job they're hired to do. In other words, if you show up to work, you can just say, well, they showed up to work, so therefore they were working, even if there was frolic and detour that went beyond the scope of their work. Do you understand my concern? It's a poor question, but do you understand the concern?
Yes, but the idea is that these three elements are connected. So at the time that the individual was committing the criminal offense, was the individual engaged in some particular business or project? So in other words, there needs to be a connection between those two things, and then a connection between that and whether the work on that particular project was authorized. And part of the reason why this test is a relatively simple one is that it's recognized that corporations benefit from the work of their employees, they benefit from the collective efforts, and they should not be able to take advantage of those benefits without incurring the consequences. And there's a lot of great language to that effect in beneficial finance.
Mr. Robbins, don't you have to show that Mr. Rowland was authorized to hire people on behalf of Martin's?
Well, no, we have to show that he was authorized to engage in the corporate business or project in which some corporate business or project in which he was engaged at the time that he committed the criminal offense. And here, the corporate business or project of ensuring the cleaning of clients' facilities, and this I think also relates to the question previously asked. It's not that it just happened to coincide. It was directly related to the criminal conduct. He furthered the criminal conduct through the cleaning work of Martin's Maintenance. He forced these individuals to work for his employer on projects that he was supposed to do, and he facilitated that by giving them Martin's Maintenance uniforms and transporting them to Martin's Maintenance client facilities and introducing them to Martin's Maintenance supervisors. And those supervisors provided instructions to SD, for example. And he logged in AC at the facility using the Martin's Maintenance system for doing so. And that's how he furthered his criminal scheme. So here, there was such an integral relationship between his work for the company and his criminal scheme that it makes the application of the test in this particular case rather easy. But
doesn't the company have to know all of that, Attorney Ravitz?
No, in fact, it's established that the company does not need to know of his criminal activity, and in fact, they can be faced with criminal liability even if they have prohibited conduct of that type. So for example, in LAL, in the Angelo Tedesco court made this observation. The company had a policy that told bartenders don't serve minors. Well, this bartender served minors anyway, and the company could be criminally liable. And the Angelo Tedesco company had a policy that said, don't back up your truck if your backup alarm isn't working. The driver did it anyway. He was.
So I know that
found,
you say,
yes.
citing Springfield, that it's mere knowledge, at least under the collective knowledge doctrine. Can you help me with where the knowledge component is under the vicarious liability?
Okay, and let me be clear, by the way, I'm not saying that there is no knowledge element for labor trafficking. I'm saying that when we apply the corporate criminal liability test, the corporate officials, the management did not need to know of his conduct.
Sure.
But there is, of course, a knowledge element to the corporate criminal liability test. And that the word knowingly basically precedes all the other elements of the test. But it is, the mens rea is one of just mere knowledge. It's not specific intent or recklessness. So it does fit within the test for application of the collective knowledge doctrine in Springfield Terminal Railway.
So the judge, I believe, in his memorandum of decision, opined that the Commonwealth didn't present evidence that the corporation knowingly benefited from Roland's forced services. So could you speak to that?
Sure. The essentially what the judge concluded was that yes, the company benefited, but it didn't realize that it was benefiting as a result of his Roland's criminal conduct, and specifically the judge and the company itself, they rely on an exception to the general rule that an employee's knowledge is imputed to the corporation. So in other words, when we apply the collective knowledge test, we are saying that Roland's own knowledge of his conduct can be imputed to the corporation. And the judge and the company say that it can't be because of an exception, namely the faithless
Agent.
Thank you, the faithless agent exception. And there are a few reasons why we say that doesn't apply. First is that it's never been applied in an appellate decision in Massachusetts in a criminal case against a corporation. It's also as to whether it should be applied. It's very difficult to reconcile that with the principles that I just said a moment ago, which are well established, that a corporation does not need to know of an employee's conduct, and in fact could have prohibited the type of conduct that was engaged in. The employee could be acting contrary to instructions previously given and policies previously established, and the corporation could still be liable. So it's hard to reconcile this faithless agent concept with those established concepts in the law of corporate criminal liability. Also, the test itself requires both fraudulent conduct toward the principal and an absence of benefit for the principal. And we say here there was neither, because Roland, the idea, the theory as to which, as to why Roland was acting fraudulently towards the company, according to the judge and the company, is that he had the employees give false names. But the fact is that was the type of thing that one manager told SD to do. He suggested that she use someone else's ID, and that in turn was consistent with the company's method of operating. When they would encounter employees, because she'd indicated that her green card was in process. When they would encounter employees who were undocumented, they would send them to one particular subcontractor. They would not make records for such individuals. And so that was consistent with the company's method of operating. And in fact, there was another manager, Brandon Arujo, who suspected that Roland was subbing other people in for him and having other people do his work for him. But he said, the message I keep getting from the company, from all these different people, is just do whatever it takes to get the job done. And in fact, Roland was the type of person, he was the point person. He was the go-to person. If you needed somebody to work on a holiday, or you needed somebody to work long hours, or to go a distance. And so for all those reasons, he looked aside. Other company officials looked aside. They saw that he was at times in two places at once. They saw that he was billing an impossibly high number of hours, and they looked aside. So to say that Roland was defrauding the company would not be fair. Roland was acting consistently with the way that the company operated, and it would also have to be shown, as I said, that there was an absence of benefit for the company. Now the company says, "Oh, well, now that we got caught, we're in a very difficult situation, and we're not benefiting on the whole." But the fact is, at the time, they were benefiting, because Roland would have SD and AC do work for the company, and the company would invoice its clients, and its clients would be, their orders for cleaning services would be fulfilled. It can be inferred that the company collected on those invoices. He would have them wear Martin's uniforms, so the company would be promoted. So the company was benefiting. In fact, in some cases, as I said, if he was in two places at once, the company was benefiting even more than it ordinarily would from having one employee work for it. But then also, as far as this faithless agent concept, there are two exceptions that are recognized in Sunrise Properties and in other sources. And one is where the agent's failure resulted in a violation of a contractual or relational duty of the principal to a person harmed thereby. And here there was such a violation, in that these people who actually perform work for the company weren't paid. And then the second exception is that where, to the defrauded party, the agent was apparently acting for the principal. And here that was the case too. I mean, just as one example, Roland gave them uniforms, told them to wear Martin's uniforms, transported them to Martin's facilities. He introduced them to Martin's managers. So clearly, he presented himself as acting for Martin's, in having them do the work that he was forcing them to do.
Right. Can I just ask you, if we could, for a moment, back on the judge use of the Wang Labs test? I understand why you say that is not the appropriate test, and you cite beneficial, right, for that proposition?
Yes,
because that's where the
and its progeny. Yes.
Okay, but beneficial is the first case, at least, that you cited and that I found from 1971 that addressed the test within the criminal context. Okay.
Yes.
You make a statement on page 18 of your reply brief, and I will ask your brother counsel this, that there was no case that recognized a common law crime of, I hope I say this right, peonage in Massachusetts. Can you speak to that? Does it matter in this case?
I think, okay, the way that issue came up was that
it's under the faithless agent, right? Because whether or not Roland's activities can be charged to the defendant in terms of their knowledge.
Yes, and that was the company's way of arguing that the collective knowledge doctrine doesn't apply, because under Springfield Terminal Railways, it only applies where there's a crime that was not known to the common law, and they're saying that this crime was known to the common law. But so there's a few things that we say in response. One is that we couldn't locate any case recognizing that as a common law crime in Massachusetts. Or also, if you compare the elements of the crime of peonage that they describe based on a federal case to the elements of labor trafficking here, you see that they're not the same offense. I'm basically borrowing
the forced services requirement.
Well, looking at the test as a whole. So for example, peonage requires some indebtedness, and the labor trafficking statute here requires for services by way of one of a series of different acts. So I'm borrowing from the double jeopardy context here in looking at whether these two are the same offense or not. And applying that test, you see that each one has at least one element that the other one doesn't have. So they're not the same offense. And in fact, if it were the case that, as they seem to argue, that it's enough to point to something that's kind of sort of similar in the criminal law, well, then how come the Springfield Terminal Railways case didn't say that that the offense that was at issue there, failing to report an oil spill, was comparable to the common law offenses that that cover things like pollution or misprision of a felony. We cited a footnote for elaborating on some of the common law offenses that could be seen as having some similarity to the offense that was at issue there. And yet again,
but arguably, right, peonage could be, in today's parlance, a lesser included offense of labor trafficking.
Again, I wouldn't say it would be a lesser included offense, because it's each one has an element that the other one doesn't have. And the offense that's at issue here, it was adopted by statute. It contains, looking at both Section 49 and Section 51 together, it contains a series of elements that do not appear to describe the same offense of peonage that they describe. And again, so far we have not seen any evidence that, and they have not cited any case showing that peonage was even a common law crime in Massachusetts.
I think Justice Neyman has a question.
I want to go back to the third prong or third element of vicarious liability in your citation for LAL. There, as I understand it, the agent had authority or power to sell alcohol.
Yes.
And he did so in contravention of the policy to sell to minors. Suppose that instead of selling alcohol, he was dealing drugs while at work, but in the back room. So he wasn't at the bar and he wasn't selling alcohol, but instead he was dealing drugs in the back room. Would the third element of vicarious liability still apply?
I would say no, because he would not have been engaged in a corporate business or project. But that's different than what we have here for the reasons that I stated. There's here Roland's human trafficking, his labor trafficking of these two individuals went hand in hand with his work for Martin's, and the fact that Martin's had these clients that it was obligated to clean and that he was obligated to clean, and that would then tender sums of money to Martin's. He used Martin's and its whole cleaning structure to further his labor trafficking scheme. So it's distinguishable from that situation where somebody maybe just happens to be on the premises, but they're engaging in a crime that really has nothing to do with the business.
Okay, I think we're going to leave it there. Thank you very much.
Thank you.
Mr. Radcliffe.
Good morning, Your Honors. Richard Radcliffe. With me is Thomas McAndrew for Martin's Maintenance. I'd like to start maybe by first addressing Justice Neyman's question on LAL. That issue that Justice Neyman raises is very similar to what we have here with Martin's Maintenance. The bartender at the bar is there. He has the interaction with the patrons at the bar because he's serving them. And if he says to them, yeah, I have some stuff in the back room, if you'd like, some cocaine or whatever, I've got it in the back room, and he's using the facilities, he's using the bar facilities. So the broad interpretation that the Commonwealth is arguing this court to adopt with respect to section 3 of the test is just, it just engulfs it. It makes the corporation liable for almost anything that a faithless employee does.
What's
What
your
would-
best what's your best case for that proposition?
Well, I think that beneficial, I mean, I think we go back to the beginning with beneficial finance. I mean, one of the things that the Commonwealth is arguing here is that there is this vast difference between civil and criminal liability. And while beneficial finance indicated that there was some difference, it's really not the difference that the Commonwealth is arguing here. If you look at the beneficial finance case, the issue in that case, because that was obviously after trial, were the jury instructions that the trial judge in that case provided. And those instructions stated in part that the Commonwealth must prove beyond a reasonable doubt that there existed between the guilty individual or individuals and the corporation which is being charged with the conduct of the individuals such a relationship that the acts and the intent of the individuals were the acts and intent of the corporation. Or to put it differently, the Commonwealth must prove beyond a reasonable doubt that when the individuals were acting criminally in committing the acts which constitute the crime and having the intent required for the crime, the corporation was actually so acting. So the court went on to say, how do we determine that? The Commonwealth must prove that the individual for whose conduct it seeks to charge the corporation criminally was placed in a position by the corporation where he had enough power, duty, and authority to act on behalf of the corporation, to handle the particular business of the corporation, or to project or project of the corporation in which he was engaged at the time that he committed the criminal act, with the power of decision as to what he would or would not do while acting for the corporation. And that he was
Language that I read to Attorney Ravitz in my earlier question.
Yes. In this case, I mean, that's our best case. I mean, in this case, and all the cases follow from that, Your Honor. This case is, and if you look at what.
But you're parsing the actions, right? Attorney Ravitz is saying we need to look at this continuing course of conduct. You're looking at, for example, taking the passport or the individual actions. Aren't we required to look at it as a whole?
You're looking at the crime here is labor trafficking, and the crime is forced services. So you have to look at first, what are the acts that constitute of the forced services? And the act is forcing somebody to work against their will. So those are the acts. That's the actus reus. So when you look at what Rowland did, and if you look at what Judge McGuire determined with respect to the third count, he said the defendant, meaning Martins, did not authorize Rowland to hire janitors. There's no evidence that he was authorized to hire janitors, to determine their rate of pay, or to compel them to provide forced services. Rowland was employed as a janitor. He was employed to clean. He wasn't employed to ensure that the facilities got clean. That's the management's role, to go over and check. Personnel decisions such as hiring other workers or to control the amount and method of paying other janitors, such duties are fundamentally different in kind from the type of work the defendant would authorize Rowland to perform. Example, taking out trash, mopping floors, etc. That's on page 9 of Judge McGuire's decision. At page 10 of his decision, he exerted most of his control over the victims outside of work. He actually controlled all of his control, basically. Everything that constituted, and we point out in our brief as to what the Commonwealth said constituted the forced services of the labor trafficking, taking the passports, everything that he did, threatening them, occurred at a different time than when Roland was actually working. Judge McGuire said he exerted most of his control over the victims outside of work hours and work sites, going so far as to reside SD in order to have control over her life and finances. He goes on at page 10. Most of the forced services described above include seizing victims' passports, impoverishing them, physically restraining SD, and threatening to have SD arrested. All occurred outside the work hours in workplaces. He goes on to say the purpose of the scheme was to benefit Roland. In beneficial finance, the purpose of the scheme, the bribery scheme, was to benefit beneficial finance. Then he goes on to say the heart of the scheme was to divert earnings of other workers into his own pocket, Roland's own pocket. And that he says Martins gained no advantage from the diversion of earnings. The cost was the same no matter who did the work. Further, Roland concealed the scheme from the defendant by misrepresenting the identities of the persons who were performing the services. So basically, the Commonwealth is arguing that the civil test is somehow so different. It's really not that different. If you look at the scope of authority and scope of employment are basically the same.
But in some ways, counsel, this is almost a sufficiency argument, right? We're at a decidedly lower standard of probable cause.
We are, but there is no evidence that was presented. And that's what Judge McGuire determined. There was no evidence that was presented that Roland had the sufficient authority so that when he was acting as the judge in his decisions regarding beneficial finance, that his actions were the actions of the corporation, because he wasn't cloaked with the authority to do the act which he did. He didn't have the authority to take someone's passport, to threaten them, to actually force them to work. That wasn't his authority. His authority was to go to the place where he was told to go to clean the floors, to clean the windows, whatever else he did. That was the authority that he was cloaked with. So if you look at beneficial finance, that's what you have to focus on. What the Commonwealth is really splitting hairs here is that they're saying that scope of authority and scope of employment are two different things. I mean, if you look at the beneficial finance case, they base it a lot on the MyBread case, which is actually a civil case. We cite in our brief a First Circuit case, United States versus Sonata, at 689 F. 2nd 238 at pages 241 and 242, where the court says, imposing corporate criminal liability where the employee was performing acts of the kind which he was authorized to perform, or said another way, where the agent was acting within the scope of his employment. So authority and scope of employment they have to be basically the same thing, because where does the employee get the authority from? He gets an authority from what he's hired to do.
Do you agree that the judge should not have applied the Wang Labs test and instead been directed by beneficial?
Well, he didn't really, he cites the Wang Labs test as authority, but he didn't apply the Wang Labs test. If you look at what he said is that he discusses the authority, the scope of authority, and it's almost an afterthought that he puts Wang Labs in, and Wang Labs, as we say, scope of authority is almost the same thing, and that the Commonwealth has seized on that and said this is some big mistake. It's not. In beneficials, the court actually says at page 270, there is no distinction in essence between civil and criminal liability of a corporation. I mean, there is some, they go on to talk about some some small differences, but in essence, there's really no difference. And then in Life Care of America, Inc., 456 Mass at 833, the court says, our previous cases has predicted a finding of criminal liability against a corporation based on a superior of respondeat superior. Respondeat superior is scope of employment, which is the same as scope of authority. The
Do you
Commonwealth.
agree with Attorney Ravitz that we don't, if we were hypothetically to find there was probable cause for one theory, that would be sufficient? We don't have to necessarily conclude that there was probable cause under both theories.
Well, the case law indicates that there are two theories of determining corporate criminal liability. The more established theory, as he said, is the vicarious liability theory. There is the collective knowledge, and we point out why collective knowledge doesn't apply. We have the peonage argument that because to apply collective knowledge, it has to be a crime that wasn't known at common law. And then we also point out you can't have charge if there's a unfaithful agent, you can't charge the principal. And I don't think there's obviously there is no argument. There's no evidence that Roland was a faithful agent. He was a faithless agent. He was supposed to be working, and he had somebody else working for him. That is the definition of a faithless agent. So, basically, the Commonwealth's argument rises and falls on as far as the section 3 of the test, rises and falls on how you, as Justice Neyman has pointed out, how you describe the authority. And there is no evidence that Mr. Roland was responsible for procuring cleaning services. There is just no evidence of that.
As I asked Attorney Ravitz, I asked something to this effect. What guidance do we have in the case law in terms of determining what to look at? And when I say what to look at, I mean in terms of discerning what the specific actus reus was here.
So,
and what authority
so the
conferred.
The actus reus for forced services is that you're forcing somebody to work against their will. And that the acts are things such as restraining the individual, taking the passport, threatening the individual, withholding the pay of the individual, making the person, like in a peonage case, is subservient to them, that they have no free will on their own. They can't leave and say, I don't want to work here. I don't want to work for you. I want to work for somewhere else. That's the very essence for services. And one of the things that I want to point out, and it's in our brief, is that Roland wasn't performing his his scheme of forced services wasn't limited to Martin's maintenance. I mean, he was doing this, as we point out in the records that we received from the grand jury. There were from the Commonwealth that were presented in the grand jury. There were other elements, other times that he had forced services. He had somebody, I believe, SD, working at the Islamic Academy, at the woman who owned the Islamic, or some connection with the Islamic Academy at her house. There was another woman who worked at another facility through a temporary agency, where Roland was getting the money. So it's clear here that his scheme, it was Roland's scheme. It wasn't Martin's maintenance scheme. This wasn't just because he worked as a janitor for Martin's Maintenance. He used whatever position he had and whatever way he had to get these women to provide funds for him. And that is the actus reus, Your Honor. So again, there in its reply, the Commonwealth, and Mr. Rabbits mentioned this, in its reply, the Commonwealth mentions Manny Martins as saying, I don't care who the hell cleans the place, but just get the place clean. This was not said to, this was said to Brandon Araujo, not Mr. Rowland. And that he also talked about that Mr. Rowland was sort of a go-to person. There was evidence that Rowland would work on weekends, but there wasn't evidence that Martins had any indication or knew that Rowland was transferring people in and out for him. In our brief, we addressed the collective knowledge, and unless the court has questions, I believe I've addressed it here that peonage was compulsory service. In this case,
So what's the element that's different between peonage and, or you say there is no element that's different between peonage and labor trafficking?
Well, in peonage, I don't believe that there is, because in peonage, it was compulsory service or involuntary servitude. And that's the Kybald versus United States case and United States Supreme Court case at 197 U.S. 207. Peonage was forbidden at common law, and that basically peonage, you were indebted to the person who was forcing you to work. You had a debt to them. Both of these women, I mean, the four services, Rowland was making them work, and basically he said, you have a debt to me. You owe me for gas. You owe me for rent. All of those things. So they're essentially the same crime, Your Honor. And then again,
I recognize that this question is probably outside of the record, but is the case against Rowland still pending?
Yes, it is, Your Honor.
it is. And then we point out also that Rowland was a faithless agent. The Lawrence Savings Bank versus Levison case we cite, and the GTE products case at 42 Mass Ave at 299, the cases that we rely on, and we point out in the brief why the GTE case is so on point. Unless there's further questions, I will end with that. Thank you very much, Your Honors.
Being none, thank you. This was well briefed and well.
We are now live and on the record.
Welcome to the appeals court. I am William Meade. With me today are Justices Blake and Neyman. Each side is provided 15 minutes to argue, and neither is permitted to interrupt the other during argument. If the justices have any questions, we ask you to pause and do your best to answer the question. With that, our next case is 21P123, KLEIN versus DEVOTI. Ms. DEVOTI, there's a clock in up on the, you can see you have 15 minutes. Go ahead.
Yes, thank you, Your Honor. Good morning, Your Honors. As the court is aware, I did not write my brief. I read it and I signed it, but I have little understanding of its content. I represent myself pro se only because I cannot afford counsel until asset division in my divorce is final. Should I be asked any questions, I will do my best. But as the record shows quite clearly, it is doubtful that I will know the answer. Therefore, with the court's permission, I would like to read a short statement of about 450 words. For purposes of what follows, when I say that a finding is wrong, I base that on arguments I made either in my brief or in pleadings in the lower court. The record contains numerous findings concerning my motion practice and litigation conduct that are clearly wrong and that tipped the balance in critical rulings against me. Number one, Judge Sweeney denied my second motion to dismiss because she wrongly found it to be repetitive of my first motion to dismiss. Number two, Judge Fishman entered a monetary sanction because he wrongly found my motion practice on jurisdiction to be repetitive, abusive of the process, and vexatious. Number three, Judge Rufo denied my request for leave to amend my counterclaim because he wrongly found it to be unduly delayed, a defect that could not be cured by further amendment. Number four, in Appendix 7, page 54, footnote 1, Judge Sanders denied my Rule 56F request because it was based on arguments that she wrongly found to be frivolous. Number five, Judge Sanders entered a monetary sanction because she wrongly found that I had been engaging in bad faith litigation conduct throughout the proceedings. Number six, Judge Sanders entered a default and later denied setting it aside because she again wrongly found that I had engaged in bad faith litigation conduct and bad faith motion practice.
Well, didn't she find that you refused to participate in discovery or respond to discovery? Is that not true?
I don't know the answer, Your Honor.
Okay.
Number seven, in Appendix 9, page 147, Judge Wilkins found that Judges Statman and Rufo had responded to my arguments about the Superior Court lacking jurisdiction to determine KLEIN's lien. However, these findings were clearly wrong because A, Judge Statman responded to my argument about the probate court lacking jurisdiction, not the Superior Court. And B, Judge Rufo responded to my argument about KLEIN's lien being inchoate, which is not an issue of jurisdiction, but a failure to state a claim. Number 8, in Appendix 9, page 154, Judge Wilkins found that I was rightly sanctioned for filing motions for reconsideration in bad faith. However, as I noted in Appendix 9, page 239, I was never sanctioned for any of my motions for reconsideration, and nor are any findings that my reasons for seeking reconsideration were improper. To summarize, the record shows two things. First, that a clearly wrong finding that I had filed a repetitive motion snowballed out of control into ad hominem findings that my motions were abusive of the process, vexatious, intended to delay, frivolous, and made in bad faith. And second, that these ad hominem findings led to my having been unjustly sanctioned and denied the right to present my defenses and counterclaims to a jury. Wherefore, I respectfully request that this court clear my name of these pernicious and clearly wrong findings and grant me the relief I requested at the conclusion of my brief. With this, I conclude my oral argument and thank you, Your Honors, for listening.
Thank you. Seeing no questions, Ms. Klein, or is Mr. Chamberlain arguing?
I'm going to. Thank you, Your Honor.
You may proceed.
Okay, thank you. I'm going to begin by responding to what Ms. DeVoti just said and point out that all of the issues she just mentioned, whether it's granting a stay, imposing sanctions, whether for failure to conduct discovery in good faith or for vexatious litigation conduct, entering or removing a default, and making factual findings, are all issues that are within the sound discretion of the trial judge. So what we have here are basically the desire on Ms. Devoti's part to have the trial judges, and they are many in the Superior Court over the course of this 5.5-year litigation, the wish that they had decided the factual issues differently. What she's referring to as pernicious allegations, I will tell the court with all due respect, were well justified by the arguments and both the quantity and the quality of the arguments that were offered in the lower court. At some point, as I believe I mentioned in my brief, the number of motions became so ridiculous that I moved in the lower court to have Ms. Devoti get permission from the court before filing additional motions, which the court granted, so that after 30 or 35 different motions that I had had to respond to, after that point, the Superior Court agreed they would first review the motions and only ask me to spend more of my time responding if there was something in it they wanted addressed, which mostly they did not after that point. I think that it would be useful for this panel to get some flavor of the types of arguments that were floated before the court, because it's one thing to go over and recognize the rule that a trial judge has broad or sound discretion. It's quite another to hear some of the arguments that provided the backdrop for the rulings that were made by all of these different Superior Court judges.
Before you do so, could you address the appellant's contention regarding the inchoate lien?
Can you repeat that, please?
Sure. Before you proceed, can you address the appellant's argument that she just made regarding the inchoate nature of the lien?
Yes, the lien is an attorney's lien begins as an inchoate lien. It arises on the commencement of a suit and is inchoate throughout the course of the entire suit until there is a judgment, and then it attaches to that judgment. In this case, that precise thing did happen, and Judge Riley in the Barnstable Probate Court granted the lien, which really the word grant is a little funny because it
already exists.
Operates by statute anyway, it arises by statute, but he acknowledged the lien, let's say, and then directed me to bring an action in the Superior Court to determine the amount. His ruling was that an attorney's lien is a mixture of legal and equitable relief, and so there is an entitlement to a jury. I didn't ask for one, but Ms. Devoti did, so I followed the instructions and brought the suit. Now, when that judgment of divorce was vacated and remanded for a second trial, this became the unusual case where that lien, having started as inchoate, become coate, went back to being inchoate. I don't know that we've ever seen such a thing before. I certainly couldn't find anything in my research. But yes, so when Judge Rufo was reviewing it, he did correctly determine that it was at the moment inchoate, but said he saw no reason why the amount of it couldn't be determined. And so the litigation continued. Now, refusing that motion for a stay was well within his discretion. He referred to that discretion when he made the ruling. Does that answer your question?
Yeah.
Okay. So here are just a sample of some of the arguments that Ms. Devoti has floated. Early on in the case, when at the very beginning, she moved to dismiss on the basis that that there was a failure of personal jurisdiction, and her reason was that she did not transact business in the Commonwealth because she was forced to hire counsel, and so her business relationship with me was involuntary, quote unquote. Needless to say, that didn't float. Another argument she made was that the retainer agreement, which she admitted that she signed, never went into effect because she sent me back a copy by email and not an original ink signature. She argued that she was too burdened by the need to learn law and procedures in order to prosecute an appeal from the divorce, that she couldn't also handle this case, and for that reason, it should be dismissed. She argued that she couldn't afford counsel, and for that reason, the case should be dismissed. She argued when it came to responding to my requests for admissions that I violated Rule 11 by including in the requests reference to scandalous material. The scandalous material in question was her husband's suggestion that we deny that the couple, that this is not Mr. Dees and Ms. Devoti, but Ms. Devoti and Mr. Bonaparte, her first husband, the suggestion that we deny they were ever married so that we could take advantage of the more favorable rules for child support that befall children born out of wedlock. This was a suggestion he himself had acknowledged was a crazy idea, and I had certainly shut it down. However, in discovery, Ms. Devoti brought a Rule 11 motion against me for referring to that scandalous material. She argued at some point that she wasn't bound by the statements that she made during her own deposition. Why? Because the stenographer failed to properly identify her, not because she ever denied that it was she who actually sat for the deposition. She claimed that I had no right to argue that her motion practice was frivolous because I opposed her motion for a stay until after the second divorce, when she would have presumably, she says, gotten money that she could have used to pay a lawyer, because it meant by my opposing that motion for a stay that I got what I asked for, litigating against a layperson. She argued that I was not prejudiced by her failure to answer requests for admissions.
We're going to have to hold you there, Attorney Klein. Your time is up.
Admitted. Yes. Okay. I'm fine. Thank you very much, Your Honor.
Thank you. Mr. Chamberlain.
Good morning. Briefly, it is our position that Ms. Devoti's failure to produce either during discovery or in response to the motion for summary judgment, expert evidence or testimony in support of her legal malpractice counterclaim was fatal to that claim. In order to establish a claim for legal malpractice, the plaintiff must prove that the attorney committed a breach of the duty to use reasonable care, that the plaintiff suffered actual loss, and that the attorney's negligence proximately caused that loss. It is well established that an allegation of malpractice is not self-proving, and that expert testimony is generally required to establish, one, the standard of care, the attorney's departure from that standard of care, and in certain cases, including the case at bar, that the attorney's negligence caused damage or loss to the plaintiff. As this court has noted, the manner in which an attorney litigates a divorce action on behalf of a client is not within the common knowledge or experience of lay people, and as such, expert testimony is required. In this case, with regard to her legal malpractice counterclaim, Ms. Devoti did not produce evidence, expert or otherwise, as to what the standard of care was applicable to attorney-client under the facts and circumstances presented. No evidence, expert or otherwise, that attorney-client departed from that standard of care, and no evidence, expert or otherwise, that Ms. Devoti sustained damages as a proximate result of any negligent act or omission on the part of attorney-client. Ms. Devoti's legal malpractice counterclaim, it was based on the manner in which attorney-client handled the divorce, what motions she filed, the timing of those motions, what discoveries she conducted, including an allegation that she should have deposed the husband. Those are all matters beyond the ken of a layperson, all requiring expert witness testimony as correctly determined by Judge Sanders. Additionally, Judge Sanders correctly noted that our legal malpractice plaintiff is alleging negligence in the prosecution of a claim. That plaintiff, that party, must establish that he or she would have obtained a better result had the attorney allegedly exercised adequate skill and care. In this case, Judge Sanders correctly found that Ms. DeVoti had no reasonable expectation of establishing that. The appeals court reversed and remanded, not based upon any negligent act or omission on the part of attorney-client's part, but because of the trial court's abuse of discretion in denying attorney-client's motions to have Ms. DeVoti participate remotely in the trial. So given the lack of expert testimony, given the lack of any proof of better result, summary judgment was properly entered in attorney-client's favor as to the counterclaim. To the extent that there was any effort by Ms. DeVoti to delay a ruling on the motion for summary judgment, and to the extent that that was a proper request pursuant to 56F, I would suggest that there is no evidence that Judge Sanders abused her discretion in denying those efforts. The assertion that Ms. DeVoti was not able to afford an expert was not asserted until late in the case. It was contrary to what she had indicated in her answers to expert interrogatories and her supplemental answers to expert interrogatories. And I think coupled with the litigation conduct of Ms. DeVoti that's already been discussed, and that formed a backdrop on this, Judge Sanders correctly determined there was no need to further delay the proceedings. Just quickly as to the motion to amend, it's our position that Judge Rufo did not abuse his discretion in denying that motion to amend the counterclaims on the grounds not only of bad faith, dilatory motive, and undue delay, given that it was filed less than 48 hours before Ms. DeVoti's deposition, which took much effort to get scheduled, and which Ms. DeVoti said, if we proceeded at that time, just having been presented with this motion to amend the counterclaims, not having a ruling from the court, if we proceeded then, she would not voluntarily make herself available for further deposition. It was clearly an effort to further delay the proceedings. Also, as noted by Judge Rufo and is conceded by Ms. DeVoti in her opposition materials, both to the summary judgment motion and the motion to amend, many of the proposed amended counterclaims were duplicative of the allegations already included in the original counterclaim. And given that by the time the Rule 56 motion came around, there was still no expert evidence, the proposed amended counterclaims would have been futile.
We are now live and on the record.
Welcome to the appeals court. I'm William Meade. Sitting with me today are Justices Blake and Neyman will be the panel for your case. And that case is 21P616 DCF versus father. I remind you all that this is impounded, so please do not use any names and refer to people by titles or some other designation other than name. With that, Attorney Krasner.
Thank you. May it please the court, I'm Sherry Krasner on behalf of father. My client is watching these proceedings on the live stream. This is not a case about whether DCF used reasonable efforts. Sadly, very sadly, that ship has already sailed. It is a case about whether on this record, there was sufficient, clear and convincing evidence that the termination of father's rights was in the child's best interest. While we don't dispute that father was unavailable at the time of the trial and that a judgment that the child was in need of care and protection could have entered at that time, it is that portion of the judgment that severed all of father's rights to his son that we dispute. Think about the evidence or the lack of evidence that was available to the judge in this case. The case was before the court for 33 months. In those 33 months, my client saw his child perhaps a dozen times, and not once, not even virtually, in the 11 months before trial. For those few contacts that existed, all of those contacts were positive. There's nothing in the record that suggests that father was not appropriate with his child. In those 33 months, there were no service plan tasks for my client. He was never assessed as to what deficiencies existed. And
Attorney Krasner, how do you respond to the department's argument that these issues are waived because no abuse of discretion motion or similar pleading was filed in the juvenile court?
well, again, as I said, we're not here arguing reasonable efforts. We understand that that may have been waived. But
Well,
what we're-
but your argument, maybe you're recasting it, but it seems to me that it boils down to reasonable efforts because you say the only thing the judge really went on is his prior criminal record and his history with respect to his other two children. There wasn't any other evidence because your client was incarcerated, the visits were stopped. I mean, it seems to me to be a recast of a reasonable efforts argument.
Respectfully, I would say it's no efforts. I mean, the department didn't do anything here. And so what we have, the record on which the judge made her decision is just so sparse. And I would remind the court that the standard is clear and convincing evidence. I mean, the judge even concedes that the evidence as to father's older children was anecdotal. There were no 51As or 51Bs or findings of fact from any other proceedings that were introduced here. The judge sort of pieced some things together, and I think she got some things wrong from some old criminal records. So again, it's not, I think what the department did in this case or didn't do, it's the elephant in the room, but I think when it comes down to what this case is about, it's about whether the judge had sufficient evidence before her on which she could make a finding that of such consequence that this father should never have any rights to this child. And
so what should the department have done?
Couple of answers to that. First of all, they should have provided virtual visits during the pandemic. But there's certainly evidence that they had those capabilities or that prisons had those capabilities. But also the court could have found, and perhaps we didn't even concede, should have found that in January of 2021, the child was in need of care and protection. Father was not available, and the record evidence is father would not have been available. The earliest July of 2021, the latest October 2021. That's set out in the record. So they could have found that the child was in need of care and protection, and the aunt could have been designated the permanent custodian of the child. And then under 119, section 26, any party has a right to come back no sooner than within 6 months and say that there's a change in circumstances. Father could have brought that petition after his incarceration ended, after he established a home, a job, and other things, and asked for a return of custody of the child to him. Or conversely, if he failed to do the things that he could or should have done after his incarceration, the department could have filed a petition for review and redetermination and sought a termination of his rights at that time and said, look, he's been out. He hasn't been visiting with his child when we set up visits. He hasn't established a job.
But let's assume that the department did arrange virtual visits and all of that. How do we measure that? I mean, the child was born in 2018, right? And he was at least incarcerated till July, maybe as late as October of 2021, which is certainly most of his life, the child's life. How do we balance the child's need for finality and security with your client, who would arguably have a lot of work to do before he could be a custodial parent?
Absolutely. That's a correct proposition, Your Honor. But there are a few things. If that was the sole reason that the department was seeking to terminate rights because of the bond that this child, he lived with the aunt, not even when, he was already living with the aunt when the petition was filed. I mean, this
Right.
is his caretaker. This is who he's bonded to. We don't dispute that. But if that was the sole reason that the department was then seeking to terminate rights, then the department would have had to make, strike that, the judge would have had to make findings about father's inability to deal with that, the trauma of being separated from his only caretaker, and his ability to then provide for the child. And we know about this from several cases, but including adoption of Zoltan, which I know Justice Meade was the author of that opinion. And that it's clear that every child bonds with their caretaker, and it will be traumatic to be removed from that caretaker. But in this case, where we don't know if father had the capacity to meet those needs. I mean, we know a little bit because father was always appropriate with the child during visits. He was nurturing, he was kind, he asked good questions about the child's medical needs, about the child's development. But if that was the only reason that the judge here was going to terminate, there's error, because she didn't do what adoption of Zoltan and the predecessor cases to that case said that she needed to do. And again, too, this child was never going to be removed from the aunt's house in that interim period, too. Father wasn't asking for that. That's not ever what he was asking for. He was asking for some additional time after his incarceration ended, in which he could demonstrate his fitness to parent the child. Again, too, when termination is the issue, the court has to look at those statutory factors. The judge in this case sets those out in strike that conclusion of law 35, and she goes through the subparts. So she says 5 of them are applicable. However, 3 of them are all about whether the department provided the appropriate services to father. And as I said out in my reply brief, we argue that evidence isn't there. Another factor she finds applicable has to do with lack of effort on father's part, but not sure what efforts he didn't make. She doesn't specify that. And she also does make a finding that he complied with the plan, as it were. And then that we circle back to that one about the bonds. And here again, that really seems to be what this case is all about. And because she didn't make the necessary findings as to father's inability to meet the child's needs upon being removed from the only caretaker that he knew, this court, we would argue, can't sustain that portion of the judgment. Again, too, father, we don't deny the father had a serious criminal record. He did, but the case law says that can't be the only reason that a court terminates father's rights. And also, very confusingly, under those same section subparts in the judge's conclusion 35, she says father's conviction of a serious felony is not one of the things that she thought about in determining that father's rights should be permanently severed to this child. I also, this child, to the aunt's credit, he was doing very well in her care. He had received early intervention. He didn't have serious medical needs, So again, from the little bit of evidence that we have in terms of father being able to meet the needs of this child and his psychological needs if he were removed, this seems to be a child who did not have serious special needs such that that would be a strike against father. That doesn't seem to be the issue in this case, again, from the very little bit of record that we have here. If the panel does not have any further questions, I'll do something I never do, but end early and rest of my brief. Thank you.
Thank you. Mr. LaFleur.
Thank you. Good morning, Your Honors. May it please the court, Assistant Attorney General Michael LaFleur, appearing on behalf of the Appellee Department of Children and Families. The department will be taking 10 minutes of the appellee's time with the balance to counsel for the child. The department asks that you affirm the adjudications and orders of the Boston Juvenile Court. Both parents were obviously unfit at the time of trial, and the court's determination that father's unfitness was likely to continue indefinitely was supported by clear and convincing evidence. As were all the court's ultimate conclusions, the court identified several obvious and significant parental deficiencies beyond the fact of the father's serious criminal history and incarceration in prison at the time of trial, both of which the court appropriately weighed as part of the totality of the circumstances. And its ruling properly made the child's health and safety a paramount but not exclusive concern. The father's parental deficiencies included, one, his lack of a realistic and credible plan to care for the child or to navigate the child's transfer to his care from the aunt's care. A lack of a significant...
Let me interrupt you.
Oh, certainly, Your Honor.
Let me interrupt you. First, it may be helpful if you slow down a little bit and move your mouth a little bit away from the computer because your presentation is a little bit jumbled. Thank you.
Oh,
but I have a question for you.
Certainly.
Having read through the record, should we be concerned that the judge's determination here stands for the proposition that a parent who is incarcerated can lose parental rights exclusively on that basis without more?
No, I do not think so, Your Honor.
Why?
That is, so it's clear from the decision here that on the one hand, it's clear from the decision that the court would not have made a different ruling even if the unspecified additional services were offered or a fuller assessment made or virtual visits during the pandemic were conducted. Because the case did not turn on what the father did when he was with the child. It was about whether the father could parent the child or not. And this was based upon the pattern of criminal conduct and recidivism that had gone on for a period of most of the father's adult life, I believe, starting in 2006 and continuing through the time of trial. He had never been available to parent. There was certainly some ample evidence in the record to support the judge's conclusions regarding his relationship with his other children, his lack of a significant parental connection with his other children, and the fact of that as being a harbinger of his capacity to care for this child. And this father had a demonstrated inability to see his role in the child's involvement with the department, and he was unwilling to take responsibility for his role in the child's involvement with the department. And he had a lack of insight into the connection between his pattern of incarceration and his absence from his children's lives. So there was a lot more than just the father's incarceration. In the court, I think to father's position regarding factor 13 under chapter 210, section 3C, here the court explicitly finds that that's not applicable, that the father is getting out of prison. The concern is not that the father's incarcerated, it's that he has a pattern of conduct that demonstrates unfitness, a lack of insight, a lack of a realistic and credible plan to care for the child. And it's sort of at bottom here, the court properly considered the potential effect on the child of his separation from the aunt, who had voluntarily assumed responsibility from the child for the child from the outset, and was the only family member to have done so, and by all accounts, including fathers, has been doing a wonderful job caring for the child and meeting the child's needs in a stable and loving home environment. And yet that is not the sole and decisive factor. The concern about traumatic separation from the aunt was not the sole and decisive factor. Here, the court just didn't, as it was entitled to do based on its findings, did not credit that the father's receipt of services, which he did credit him for, had effectuated a substantial and material or permanent change in the circumstances that led to his neglect of the child. And that the lack of effort here was the compounding of the lack of a connection with his other children, the demonstrated pattern of absence from his other children's lives, including only a peripheral awareness of his oldest child's circumstances, where the oldest child was in the department's care and father was unaware of whether he had been adopted by his grandfather. And also the lack of insight into what was causing the absence. So here, at bottom, I think the aunt really put it well, where she talked about it during her testimony that the lack of reliability by both parents in their coming in and out of the child's life. Here, I think the court's decision really, I think conclusion of law 37 really sums it up, and I see adoption of Nicole, this court's decision in 1996, as being pretty instructive here. But neither parent has ever cared for this child in a way that the child deserves. And there's no likelihood they ever will. And there's ample evidence to support that. And the aunt will do that. And there was just no reason to wait any longer. And more virtual visits with the child would not have changed that circumstance or undermined that conclusion. And again, I do to follow up on Justice Blake's question of father's counsel. This is the principal brief is basically a recasting of a reasonable efforts argument in the form of a sufficiency challenge. But really, by the time of a termination of parental rights trial, the lack of services is not a defense. It's the best interest of the child. And here the best interest was clearly in keeping the child with his aunt. And she was his primary caretaker for his whole life. And there was, again, no reason to believe that virtual visits with a 3-year-old with a father in prison would have ameliorated the profound deficiencies that the court had focused on. Although there were some issues with visitation, it was not terminated. The visitation was not suspended. And father did not avail himself, again, of any of the legal avenues that he could have to complain about visitation to the court. His motion to continue, whose denial he does not contest, did not request relief beyond a continuation of the trial date or any order pertaining to visitation, or even cite the regulation, 110 CMR section 1.10 that he relies heavily on in his principle. The court correctly found that the department made reasonable efforts in the circumstances here. In addition to visits, the father was provided with an action plan and allowed to show progress on tasks, including he was required to engage in a parenting program and make himself available for assessment, and he did that. And he was credited for that. He conferred with a caseworker about programs undertaken while in prison, and he presented certificates showing that he completed them. And again, the court credited that, but that was just not enough to ameliorate his other profound deficiencies, and there was no error in the court's conclusion to that effect, and it was amply supported by the record. The department was not required to bring services into prison for the father. Again, father doesn't identify what service beyond additional virtual visits should have been done. So, and just to sum up briefly with the challenge to the conclusions of law that are raised in father's reply brief, the court was not required to indicate the applicability of the Chapter 210, Section 3C factors in any particular way. And here, the court, in fact, did fully address the applicability of all the 5 identified factors in the totality of this ruling, which again has ample record support, making the adoption of Posey just inapposite to the situation. My reading was clear that the factors 2, 7, and 8 were the key factors. At least that's how I read the decision. Again, here the court is saying that the father's receipt of services had not effectuated a substantial and material or permanent change in the circumstances. It's crediting him for his receipt of services, but it's concerned about the potential traumatic impact on the child, and it's noting that the father's lack of effort, the lack of a realistic plan, the lack of insight into what's causing the recidivism is failing to remedy the conditions that create a risk of harm for the child. And again, for those reasons, the department asks that you affirm the adjudications and orders of the prosecutor.
Thank you. Ms. DeFeo.
Good morning, Your Honor. Jennifer DeFeo. I represent the appellee child. I would like to say to this court, I do believe that this should be affirmed, that the best interest of the child is presented exactly in the words of Judge Hardiman, enough. And I think that that's compelling. This child will be 4 years old next week. For the 33 months that this was pending, he lived with his aunt. His father was incarcerated every single day of this matter. I think that, the court did ask, is the incarceration the only issue? No, it's far and from the only issue. While history definitely can be predictive and relevant, what we need to look at is his present inability to have any type of plan whatsoever as to how he would care for the child upon release. He gave some blanket statements that he would need to have 2 jobs because he has 3 other children whom he needs to support. He stated he would try to find housing. He testified that on his last release, which was between 2016 and 2017, again, he tried to find housing. He didn't find it, he tried. And he worked 2 jobs during that time. The court also found incidents in which father's testimony was not credible. She felt as though father was inconsistent, that he would say on one hand that he had depression. The next testimony, he didn't have depression. One testimony, he stated he saw the service plan and complied with it. The other one, he stated he never saw it. He also has children whom he said he had a great relationship with, but he didn't have a relationship with them. He has twins who he didn't meet until they were approximately 6.5 to 7 years old. This entire time that he's been incarcerated, he's had no relationship. There was nothing to even suggest that he saw the children during that time. So while he also states that he doesn't get in trouble while he was in jail, he was in disciplinary proceedings during the onset of this matter. This gentleman, while he has good intentions, his good intentions don't overcome the best interest of my client. This little boy has had one caretaker. Other than perhaps a few weeks of his life, his aunt, who has been approved to adopt him, has been his sole world. There's been testimony from the aunt, testimony from the adoption supervisor, social worker, that it's a healthy, happy, loving relationship. In order for that to be disrupted, the father would need to show that he has the ability to handle any trauma that would arise from the separation between the child and the aunt. He can't do that. He has not been emotionally available for this child at all, nor has he been available for his other 3 children. And while he can definitely be fit to parent one and not other children, the law is clear on that, but it is predictive. It is something that this court should look at. And I think Judge Hardiman put that into place by stating that without any type of reality that he can present for fitness, it's just not something that's going to happen. Even if the department did fail to use reasonable efforts, and I do understand that that's really not the crux of this case, but it has been mentioned repeatedly, even if it were preserved, the court can still make appropriate orders about the best interest. And that's been spelled out in adoption of Ilona, which is a very critical case. That's in 459 Mass 53. When we look at the fact that DCF has no protective concerns, we look at the fact that the father himself feels as though the aunt is an appropriate placement, even though he would prefer it only be temporary, the child is adjusted. We need to look at the fact that this panel should affirm what has already happened. The judge was very clear in her factors. She elemented out in detail why she felt as though she had complied with Section 3. Unless this court were to find some type of abuse of discretion, some clear error, the court also says that there has to be no support, no evidence whatsoever. And this court should be left with a definitive and firm conviction that a mistake has been committed. That's custody of Eleanor. We do not believe that that's possible, Your Honors. Thank you.
Are now live and on the record.
Thank you. Welcome to the appeals court. I'm William Meade. With me today are Justices Blake and Neyman will be the panel for your case, which is impounded. So no names. It's 21P 243, row number 22460 versus the Sex Offender Registry Board. Ms. Green.
Thank you. May it please the court. Ashley Green here this morning representing my client, Mr. Rowe, who is a 71-year-old man who has not committed a sexual offense in 30 years. He is appealing to this court to reverse the Sex Offender Registry Board's decision that requires him to register as a level 2 sex offender. I'm going to take my arguments in order, obviously jump in at any time. My first argument is in reference to the 9 factors that were applied by the hearing examiner without denoting how much weight was given to each one. Now, the Sex Offender Registry Board has filed 2 16L letters in the last week and a half, I believe, and I know that this court has addressed this issue in those 2 unpublished decisions. And I would like to speak to those. Both of those were my cases. One was reversed and one was upheld.
So I'm
Now,
sorry to interrupt you. I'm sorry to interrupt. Did you say 2 16L letters?
I only have
Yes.
one.
I have the one dated January 24th, 2022. When was the other one filed?
Today.
Oh,
Okay. We'll take a look at it.
Okay.
Attorney Green,
so-
since they were your cases, and I was going to ask Attorney Bosse this, but was it the same hearing examiner in all of these cases?
That I do not know. I don't remember.
Attorney Bosse, study up for that question.
So
I
I have a follow-up on this issue, which is, I understand what you're seeking and why you're arguing it. My question is first, does the statute require the SORB to attribute certain amounts of weight to any of the particular factors?
The statute does not require it. The
Okay,
statute
regulations.
The regulations do not require weight to all factors, only certain factors, and that is correct. However, the problem becomes when this court and when the Superior Court is reviewing the cases, they have to surmise what the hearing examiner was thinking. And it is impossible for us to know how much weight was given to each if there isn't some explanation. Now, I know I'm asking for specific, threshold, moderate, high, or full. If this court would just not even say it has to be specific, but give some light to how much weight is in each factor, that would at least give us some indication that this wasn't just a checklist approach of the factors to create a decision that reaches, okay, it's a level 2 because I've applied 9 factors that are high risk, 2 factors that are low risk, so I'm going to give them moderate. That's a checklist approach that we know we cannot use in these cases.
Did the hearing examiner, in delineating the factors, give some background or context as to why the factors did or did not apply?
The hearing examiner in this case, and in many cases, gives one sentence that connects that factor to that case. So for example, it will say the factor 8, let's take for example, weapons, violence, or infliction of bodily harm. The hearing examiner will say, in this case, the petitioner's sex offenses were violent and included use of a gun. This risk factor applies. The problem I have with that, and I took that as an example out of the blue, is that we don't know how much weight they gave to it. And when you have an offense that occurred 30 years ago, if this hearing examiner is applying full weight to this factor, that is problematic because these static factors never change. So 20 years from now, when my client is 91 years old, these hearing examiners can still give all this weight to static factors without recognizing that it occurred 30, 40, 50 years ago. So that's the problem when there isn't weight assigned, is that it doesn't matter how much time has occurred, the hearing examiners still have the power to lay out a list of factors and say, all these high-risk factors applied in this case, therefore he is a moderate or a high-risk offender. And there's no taking into account that it's been 30 years since this occurred. I understand if these factors were applied and the offense occurred 5 years ago, and the hearing examiner is saying, look, we have factor 7, the relationship between offender and victim, factor 8, factor 9, all those static factors that just occurred because this just occurred within 5, even 10 years. But and I understand that they'll say these factors apply and therefore this is a moderate or a high risk case. Okay, I get it. And that's why we have to take these on an individual basis. But when you have a case that's 30 years old and you have a hearing examiner just checklist of these factors, factor 7, factor 9, factor 10, and then they reach moderate risk and they're not taking into account that this happened 3 decades ago, that is where the problem lies without giving weight to the factors. So while I agree with this court, and I understand that they have made a decision about not laying out a blanket mandate that every factor needs weight, I understand those decisions and I'm not ignoring them. But I am saying in a case like this, that we have such an ancient offense, there has to be more in these decisions. Otherwise, there's no way for a reviewing court to know whether the clear and convincing evidence standard was reached, because we don't
doesn't
know.
That come in, excuse me, doesn't that come into play with factor 30 and the hearing examiner considered his advanced age as a mitigating factor?
Advanced age, but that's another issue entirely. But I'll hold that aside. They took into account advanced age, yes, but that doesn't take into account that the offense occurred 30 years ago, because that same factor and weight would apply if the offense took place 5 years ago. They could still say he's 71 years old, so we'll give moderate weight to factor 30. Okay, but that's just one factor that they gave moderate weight. And while we're on factor 30, the fact that there wasn't full weight given to factor 30 is in and of itself a reversible error. His age is a huge part of this. I mean, we're talking about 30 years ago, he committed an offense. He's now 71 years old. He's been in the community at the time 7.5 years, now 10 years, without committing any offense, not even a speeding ticket. And he's not getting full weight for the fact that he's 71 years old, when all the research shows that his decline of risk of recidivism started at age 40. So these are again, I could go through each and every factor and say how they've been misapplied in this case, but it's almost impossible unless the hearing examiner gives us more in these decisions. The blanket application.
Does the fact that your client prevailed in part in his motion for reclassification, i.e. that he was reduced from a level 3 to a level 2, suggest that the hearing examiner did consider the factors and did more than perform a perfunctory review?
It would if, to my client, there is a difference between a level 3 and a level 2. And unfortunately, in application, there really is no difference between a level 3 and a level 2.
Because of the dissemination.
Exactly. Because my client is still broadcast on the internet for the world to see. And so for his purposes, for his everyday life, while the board is going to say, well, we gave him, a reduction in his classification, that's all well and good on paper. Unfortunately, the public does not know the difference between a level 3 and a level 2 sex offender. They see a sex offender living in their neighborhood, and that's all they care about. And in this case, obviously, our argument is that my client should be a level 1 at this point, because he has proven over the decades that he does not present any risk. And the scientific research supports that is cited by the board's regulations. And that's, that goes into more of a factor analysis. And again, I just mentioned factor 30, which should have had absolute full weight. I would like to touch on factor 9, the factor that revolves around the alcohol and substance abuse, if this court wants to hitch its wagon to glaring errors, factor 9 is an absolute glaring error. We're now applying, the hearing examiner is applying.
Well, Sorb is conceding that, right? This is the one that Sorb's conceding, but saying there's no prejudice. So could you focus your remarks on the prejudice component?
Sure. So the prejudice occurs where the hearing examiner's case is falling apart, right? Every factor counts. Every ounce of weight going to risk or high risk counts. And if you take out an entire high risk factor, such as factor 9, that further highlights that this hearing examiner's decision cannot withstand judicial scrutiny. And I just think factor 9 was one that I highlighted to such a degree because it is a perfect example of taking something that's in the record and applying it as if it just happened. And this is just such an issue because this was almost 50 years ago when my client was 20, that he had a run-in with the law about a use of, I believe it's a marijuana use. I mean, what are we talking about here? We're trying to figure out who is going to put the community at risk for being sexually assaulted, sexually offended against. And we're now looking at a guy who had an issue with a marijuana charge 50 years ago to say that that somehow heightened his risk to reoffend the community in the future when he's now a 71-year-old man. That in and of itself, requires a reversal. But I think that in connection with the issues with the weight, or if this court is not inclined to discuss that weight has to be assigned, there is not enough detail or explanation to support an ultimate conclusion that there is a moderate risk of reoffending from this petitioner in particular. I think that this all weighs into my third argument, which focuses on the fact that, my client should not be on the internet. Finding that somebody who was in a romantic relationship 30 years ago where there was a sexual assault, and nobody is denying that, and my client paid dearly for it. He was in prison for 20 years for this offense. He served every day of that 20 years. And now to find that he is now subject to a lifetime sentence by having his name and his picture and his address on the internet for his neighbors to see, for his family to see all the time, that is something that is just a bridge too far for a case like this. My client should be a level 1 offender. His information should not be on the internet. He has never posed a risk to children, to the elderly. He had a romantic relationship that went awry. It was an awful incident. Nobody's denying it, but that is not what the board is set up to decide whether or not my client 30 years ago had a criminal offense. That has been decided by a jury. And he has served his sentence. The board's power is to decide whether the community is at risk. And in this case particular, my 71-year-old client does not put one person in this community at risk, and therefore his information should be removed from the internet. He should be a level 1 offender, and I ask that this court agree with us on that. If there are no other questions, I would rest on my brief.
Seeing none, thank you. Mr. Boss.
Thank you.
Yes, and good morning, Your Honors. May I please the court, John Bosse for the Sex Offender Registry Board. I'd just like to start off by apologizing. If I was looking away from my screen, that's because I was doing my homework on Justice Blake's question, and I was able to.
Is it the same hearing examiner?
No, so
Okay.
it's not the same hearing examiner.
It seems
yesterday,
like that your client could avoid a tremendous amount of issues on appeal if they put a little bit of meat on the bones.
And I agree, and that's part of the reason why I submitted the two 16L letters. One 16L letter was was dated January 24th, and the other is dated February 1st. And that unpublished case was just published on January 24th. And perhaps I should have put a footnote under February 1st that will be forever remembered as the day Tom Brady retired from the NFL. But I did not do that. Nevertheless, Your Honor.
So those two cases essentially say there's no requirement in the statute or the regulations to attribute specific weight to any of these factors.
Correct.
However, I believe both cases, and they're not precedent, they're unpublished, but both cases also state, geez, it would be a really good idea to do so. And it would be fair to the parties. As Justice Blake said, it might make everyone's life easier in terms of conducting review and analysis. So begs the question, since you have that message, why or why not do so? I understand there's a separation of powers issue here before Justice Meade gets to that, but could you still address my question?
Yes. So again, I agree with the unpublished opinions that it would be helpful for the examiners to explain the specific weight that they are giving to the regulatory factors that they apply. And I have shared that with my supervisors and colleagues at the SORB. But under there's no decisional law that requires hearing examiners to explain the weight. What the decisional law from this court in 2019, and I cite that case in my brief 22188, requires is that in order to avoid an arbitrary and capricious decision, the hearing examiners have to consider risk factors that are relevant. And in this case, that's what the hearing examiner did. She applied the regulatory factors that are relevant and that were supported by the findings of fact that the hearing examiner made. For example,
right, but what does consideration mean when you're just saying it applies? Okay, so I considered it. It applies. What does that mean?
Well, in this case and in several cases, the hearing examiners just don't apply it. They do oftentimes explain why they're applying it. So as long as that they explain why they're applying the relevant factor, as a result, they don't have to specify if they're providing a specific weight. Now, there are certain factors where they do have to state whether they're giving a increased weight or a moderate weight or a less weight, but that's is specified under the regulatory language. And so again, moving forward, what I can do as board counsel is bring these to the attention to my supervisors. And I do think it's a good idea that, you know, in some cases, the examiners do explain the weight that they're given, but under decisional law that they're not required to. Again, as long as there's evidence, as long as their decision supports that they applied the relevant regulatory factors and they explain why they're applying the factors, then at the end of the day, that they don't have to state the amount of weight that they're given to a particular factor.
You know, I don't mean to shoot the messenger at all, Attorney Bosse, and I appreciate what you just said. And I also appreciate your concession on factor 9, but it certainly, it doesn't leave a great taste in one's mouth when you look at, this particular hearing examiner's decision seemed very cookie cutter, not particularly thoughtful. And I'm not saying that to be mean, and I don't know that that changes the needle on where this case comes out. But, you know, if you start to peel away the things that your sister counsel raised, it does leave me with a lot of questions. I mean, to Justice Nyman's point earlier, certainly the board reduced him from a 3 to a 2, but public dissemination is a huge issue. And like Attorney Green said, the public doesn't know the difference between 2 and 3. So can you tell us why he's a level 2?
Yes, and thank you, Your Honor. As you know, I conceded on the issue about factor 9. However, that did not prejudice Doe because the hearing examiner only applied minimal weight, and the examiner recognized that since the 1970s that there's been no issues with substance abuse. But why I believe this is a factor 2 case, and why I believe a reasonable person would also believe that, is, you know, we recognize that Doe has had 7 years of offense-free time in the community, which is certainly relevant. And he's also at the age of 69, which is even more relevant. However, he was in prison between 1993 and 2012. He did not participate in the prison sex offender treatment program, and he did not participate because he denies that he committed the governing sex offense. And he denies
he participated, as I understood the record, correct me if I'm wrong, until that point in the program where you have to take ownership of your crime. So it's not that he didn't do any of it. That's my memory. I'll check the record though.
You know, and I apologize, Your Honor, I should know this, but but my memory is he didn't participate in sex offender treatment in prison. He did participate in some mental health treatment in the community, which his therapist said that he was doing, he did very well in, and his probation officer said that Doe did well and complied with all conditions of probation. But to the state, Doe still denies that he committed the governing sex offense, despite the fact that his conduct against the victim, it was, he's obviously before the board because he engaged in sexual misconduct, but there was also 2 other women, his wife and a former girlfriend, who came forward and said that he engaged in domestic abuse against them. So it's for these reasons, you know, albeit the domestic abuse and the governing sex offense were in the 70s and 80s and early 90s, there's no evidence that, you know, he's taken responsibility for this governing sex offense and that he engaged in any meaningful treatment. And so that's why, although there's the mitigating evidence of offense-free time in the community for 7 years and the advanced age, we believe that a reasonable person would find that Doe is a level 2 sex offender. And unless the court has any further questions, the SOAR would rest on its brief.
Seeing none, thank you both. We'll take this under advisement.
Thank you, Your Honor.
Thank you.